All right now, breaking news in Washington. The Supreme Court has struck down Louisiana's second majority black congressional district in a decision that could boost Republicans' balance of power in Congress. The High Court finding that the Louisiana redistricting relied too heavily on race and snaked districts to create districts favorable for Democrats. The decision weakens a landmark voting rights law protection against discrimination in redistricting. The court heard this case for a second time in October, and it's not clear whether the decision was issued early enough for some states, including Louisiana, to consider a new round of redistricting ahead of the midterms, in which Republicans are trying to preserve a thin majority. Several states right now are in the spotlight because of redistricting. Florida, for example, set to vote on a new proposed map here soon. That could give Republicans more control on the national level. News Nation's Washington, D.C. Bureau Chief Mike Vaquera joins us. So this decision from the High Court, Mike, and good morning to you as always. What are the merits of this case going into it? What were the arguments for each side?
Hello, guys. John here. Sit down before I tell you this. The Supreme Court's conservative majority has gutted the Voting Rights Act in a ruling that could flip 10, 15 House seats red and reshape the electoral map for a decade. The consequences will ripple through every election, locking in Republican control even when voters choose Democrats. According to reporting from the Associated Press, the Supreme Court's conservative majority ruled 6-3 that a lower court violated the Constitution by ordering a congressional map with a second majority black district in Louisiana. The Supreme Court said that race cannot be a primary factor in drawing maps, even when the whole purpose of drawing that district is to give black voters a fair chance to elect their preferred candidates. The Supreme Court essentially said that fair representation for black voters is unconstitutional. And Justice Samuel Alito, writing for the majority, said that,
well, Marnie, and I think you encapsulated the entire magnitude of this case very well, and it does have major implications for who controls the House of Representatives, which party controls the House of Representatives, and perhaps just as importantly, minority representation in the House of Representatives, in particular, African-American, Black American representation in the House of Representatives. The Supreme Court appears to have reached some sort of compromise here. You referenced the Voting Rights Act of 1965. It is a landmark decision signed by President Lyndon Johnson that essentially said African Americans are underrepresented in the House of Representatives. For almost a century, there were essentially zero Black Americans in the House of Representatives. After the 1965 law, which mandated that there should be essentially majority-minority districts throughout the South that would allow more African Americans to be elected and sent to Washington. Since then, as of right now, there are 63 of those districts, 62 members of the Congressional Black Caucus in Congress.
Section 2 liability now requires evidence supporting a strong inference of racial discrimination. In other words, if you want to challenge a map that dilutes black voting power, you have to prove that the state intentionally discriminated. You have to prove racist intent. You cannot simply show that the map has the effect of diluting black voting power. That used to be enough, but now you have to prove intent. That is a massive change. That is gutting the Voting Rights Act. And Justice Elena Kagan in dissent warned that this ruling eviscerates the law. Kagan said this ruling amounts to the demolition of the Voting Rights Act, and experts are calling this a free pass to discriminate. This is giving Republican-controlled states a free pass to wipe out districts where black voters have a chance to elect their preferred candidates. This is giving Republican states permission to dilute minority voting power.
Now, in Louisiana, they cited the Section 2 of the Voting Rights Act, which incidentally the Supreme Court has now let stand, and that's the compromise here. But they looked at that district in particular and said it violates the gerrymandering principles. In other words, it is so convoluted, so distorted, this district, in an effort to draw that second majority-minority black district in Louisiana, that it violates the law. And they're striking down the Louisiana map. So what does this mean for implications for November and the midterm elections? That's the key question here, because, Marnie, as you pointed out, there are so many states that have already had their primaries the process is moving forward. Relatively few states. We've heard about the gerrymandering fights in Virginia, in Texas, in California, upcoming in Florida. There's been one in Ohio as well. Unclear whether or not it is too late to go back, redraw these maps, and redo these election districts. And that's the essential argument here in the short term. In the long term, it's a very fundamental argument about minority representation in Congress, the effects of the Voting Rights Act.
This is giving the GOP the green light to redraw maps in ways that hurt Black and Latino voters. And the immediate impact is clear. At least 7 Democratic-held seats in the South are now in play. 2 in Louisiana, 2 in Alabama, 1 in Mississippi, 1 in Tennessee, 1 in South Carolina. Republican legislators can now eliminate or weaken the Black-heavy districts that have been protecting Democratic seats. Republican legislators can now redraw the maps to flip those seats red. And that is just the beginning. Over several election cycles, Republicans could flip 10 to 15 or more seats across the South. Now let's understand what just happened and why this is such a catastrophic blow to voting rights and democracy in America. Because what the Supreme Court just did is erase the most powerful tool that communities of color had.
Supreme Court just issued a ruling on a potentially groundbreaking redistricting case that could impact, for many years to come, the power of minority voters in this country. It focuses on the constitutionality of Louisiana's congressional map and how it was redrawn. The justices determined if Louisiana lawmakers properly balance constitutional and Voting Rights Act protections. I want to get straight to CBS News chief legal correspondent Jan Crawford, who has been reading through the opinion. Jan?
Well, Major, we just got this ruling within the last couple minutes. The justices in a 6-3 vote, a decision written by Justice Samuel Alito for the other 5 conservatives, are striking down a second majority Black district in Louisiana, ruling that state officials focused on race, and that amounted to an unconstitutional racial gerrymander. Now, this decision is a major one under the Voting Rights Act. It will go well beyond Louisiana. It's going to make it, based on what we're seeing so far, it will make it harder for state officials to draw up these so-called majority-minority districts.
To challenge discriminatory maps. What the Supreme Court did is make it nearly impossible to prove that a map violates the Voting Rights Act based on its effects. What the Supreme Court did is rewrite the rules of what counts as discrimination in voting. For decades, the Voting Rights Act had a simple rule. If a map had the effect of diluting minority voting power, that was illegal. You did not have to prove that the state intended to discriminate. You just had to show that the map had a discriminatory effect. This rule was added to the Voting Rights Act in the early 1980s after Congress found that intentional discrimination was hard to prove even when the effects were obvious.
Which have been used for decades and have increased Black representation and minority representation in Congress. And it also, I think, will call into question about a dozen or so existing majority-minority districts, mostly in the South. Now, those districts, as you know, Major, have been a way for Democrats to pick up seats in some of those states, those red states in the South. So this ruling is a win, I think we can say, for Republicans. But legally, this is a Supreme Court that, going back 20 years or more, has been saying in case after case, a consistent line of cases, that the Constitution is colorblind. And that's why we've seen the Supreme Court do things like throw out affirmative action in college admissions. This line of cases, very consistent with the court's ruling today. What about the midterms? I think this ruling coming today, 6 months after it was argued back in October, may come too late to have an impact on these upcoming midterm elections. I think the focus will be going forward, limiting states from considering race.
So Congress said, we are going to make it illegal to have discriminatory effects regardless of intent. And that rule worked. That rule allowed courts to order states to draw districts where Black voters had a fair chance to elect their preferred candidates. That rule allowed thousands of Black and Latino officials to be elected. That rule protected minority voting power for 4 decades. That rule was one of the most successful civil rights protections in American history. But the conservative Supreme Court majority just reversed that rule. The court said that you now have to prove racist intent. The court said that simply showing that a map has a discriminatory effect is not enough. You have to prove that the state intended to discriminate. You have to prove that someone said something racist. You have to prove that the state's intent was to harm minority voters. That is an impossibly high bar. And the court's reasoning is absurd. The court said that a second majority black district in Louisiana relies too heavily on race in violation of the 14th Amendment. But the whole point of creating a second majority black district is to give black voters a fair chance to elect their preferred candidates. The whole point is to undo the effects of decades of discriminatory maps that packed black voters into one district or split them across multiple districts to dilute their power. And now the court is saying that trying to fix that dilution is a violation of the 14th Amendment. This is the logic of colorblindness taken to its absurd extreme. The court is saying that the government cannot consider race even when the entire purpose of a map is to reverse the effects of racial discrimination. The court is saying that you cannot fix a discriminatory map by considering race. The court is saying that the only constitutional way to draw maps is to ignore race entirely, even if that means allowing discriminatory effects to persist indefinitely. And this ruling comes after the conservative court already gutted the Voting Rights Act in a case called Shelby County versus Holder. In Shelby County, the court struck down Section 5 of the Voting Rights Act, which had required Southern states to get federal approval before changing their voting laws. That was called preclearance. For decades, preclearance prevented Southern states from enacting discriminatory voting laws. But the conservative court said that preclearance was no longer necessary. The court said that racial discrimination in voting was no longer a problem in America. And immediately after Shelby County, Southern states started enacting voter ID laws, closing polling places in minority neighborhoods, purging voter rolls, and passing strict voting restrictions. The court said we do not need federal oversight anymore. And Southern states responded by enacting a wave of discriminatory voting restrictions. Now, the court is gutting the last protection left in the Voting Rights Act. The court is systematically dismantling the law piece by piece. The impact on House seats is immediate and obvious. News outlets and political analysts say that the Louisiana ruling alone could put at least 7 Democratic-held House seats in the South in play. 2 in Louisiana, 2 in Alabama, 1 in Mississippi, 1 in Tennessee, 1 in South Carolina. Republican legislators can now redraw those districts to eliminate the black majority districts that have been protecting Democratic seats. And analysts say that if the full implications of this ruling are exploited, Republicans could eliminate more than a dozen minority opportunity districts across the South. The New York Times analysis estimated that could mean around 12 extra GOP seats. And in a narrowly divided House, where Democrats and Republicans are separated by just a handful of seats, gaining 10 to 15 seats would lock in Republican control for the next decade. And this is not something that will happen gradually. This will happen immediately. Republican legislators are going to redraw maps as soon as possible. Republican legislators are going to eliminate black majority districts. Republican legislators are going to flip Democratic seats to Republican. This could happen before the next midterm election. This could flip control of the House. And the bigger picture is that the conservative Supreme Court has systematically dismantled the Voting Rights Act over the past 2 decades. The New Yorker describes how conservative justices have spent 20 years systematically dismantling the law. First, they gutted Section 5. Now they have gutted Section 2. They have essentially dismantled the entire Voting Rights Act. The law is on the books, but it is drastically limited. The law is largely symbolic at this point. So let's talk about what this means for American democracy and for the future of voting rights and for the political map of America, because this is not just a legal ruling. This is a fundamental shift in power. This is the Supreme Court choosing the next generation of political winners and losers. This is the court rewriting the rules in ways that benefit Republicans and harm Democrats. And the first thing to understand is that this ruling allows Republican states to wipe out districts where black voters have a real chance to elect their preferred candidates. This ruling allows Republican states to pack black voters into fewer districts or split them across multiple districts to dilute their power. This ruling allows Republican states to gerrymander in ways that specifically target minority voters. This has given Republican states a green light to discriminate. The second thing to understand is the timeline. This is not something that will happen slowly. Republican legislators are going to redraw maps before the next election. Republican legislators are going to eliminate black majority districts. Republican legislators are going to flip Democratic seats. This could happen in the next 2 years. This could decide the upcoming election. And the third thing is to understand the scale. We are not just talking about a few seats. We are talking about 10 to 15 or more seats. We are talking about fundamentally reshaping the House of Representatives. We are talking about locking in Republican control even when Americans vote for Democrats. We are talking about allowing Republicans to ignore the popular will because the maps will guarantee Republican victories. The fourth thing is to understand that this is intentional. The conservative Supreme Court majority did not accidentally gut the Voting Rights Act. The conservative majority deliberately voted to weaken voting rights protections. The conservative majority deliberately voted to make it harder for black voters to have fair representation. The conservative majority deliberately voted in a way that benefits Republicans. This is a political decision dressed up as a legal ruling. And the fifth thing is to understand that this is part of a broader pattern. The conservative court has been systematically dismantling voting rights protections for 2 decades. The court gutted Section 5 of the Voting Rights Act. The court greenlit extreme partisan gerrymandering. The court allowed states to purge voter rolls. The court allowed states to pass strict voter ID laws. The court allowed states to close polling places in minority neighborhoods. And now the court has gutted Section 2. The court is systematically removing every protection that helps minorities and Democrats vote. The sixth thing is to understand that this is durable. The conservative majority on the Supreme Court will last for decades. Even if Democrats win elections, the court's conservative majority will still be there. Even if Americans vote for change, the court's conservative majority will block that change. The court is locked in for a generation, and the implications of that are enormous. And the seventh thing is to understand that the court is reshaping democracy. The court is not interpreting the law. The court is rewriting the law. The court is changing the rules of politics. The court is shifting power from one party to another. The court is deciding who gets power in America. And the court is doing this in a way that is ideologically driven. The 6 conservative justices are voting as a bloc. The 3 liberal justices are voting as a bloc. The court has become a political institution. The eighth thing is to understand that voting rights are being attacked from multiple angles. The Supreme Court is gutting the Voting Rights Act. Republican states are passing voter ID laws and closing polling places. Republican states are purging voter rolls. Republican states are gerrymandering to dilute minority voting power. And now, the Supreme Court is allowing all of this. The Supreme Court is removing the last federal protection against discriminatory voting practices. And the ninth thing is to understand that this is democracy under threat. Democracy requires that everyone has a fair chance to vote, and that voting power is not diluted based on race. Democracy requires that elected officials represent the voters. Democracy requires that the party that gets the most votes wins. But the Supreme Court is dismantling all of that. The court is allowing voting power to be diluted. The court is allowing maps to be drawn in ways that guarantee Republican wins, regardless of how Americans vote. And the 10th thing is to understand that this is about power. This is not an abstract legal issue. This is about who gets to make decisions in America. This is about whether Americans get to control their government, or whether Republican-drawn maps get to control the government. This is about whether the votes of Black Americans matter, or whether they can be diluted. This is about whether democracy is real or whether it is a facade that covers Republican power. And here is what is particularly infuriating. Trump appointed 3 of the 6 conservative justices. Trump's court is dismantling voting rights. Trump's court is allowing Republican gerrymandering. Trump's court is reshaping the political map in ways that benefit Republicans. And Trump's court will outlast Trump. Trump's judges will be on the bench for decades. Trump's judges will continue making decisions that benefit Republicans long after Trump is gone. And this connects directly to Trump's political future. Even if Trump loses an election, Trump's court is protecting Republican power. Even if Americans vote for change, Trump's court is preventing that change. Even if Americans want a different government, Trump's court is ensuring that Republicans stay in power. Trump built a court that will protect Republican power for a generation. And that court is now using that power to reshape the electoral map. And the Voting Rights Act, which was supposed to protect minority voting power, is now essentially useless. The law is on the books, but it has been gutted. The law cannot be enforced. The law provides no real protection. And Republican states are going to start redrawing maps immediately. Republican states are going to eliminate minority opportunity districts. Republican states are going to flip Democratic seats. And there is nothing that Congress can do to stop it because the Supreme Court has made Section 2 essentially unenforceable. And Americans need to understand what is at stake. Americans need to understand that democracy is under threat. Americans need to understand that their votes might not matter if the maps are drawn to guarantee Republican wins. Americans need to understand that voting rights are being dismantled. Americans need to understand that the Supreme Court is not protecting their rights. The Supreme Court is taking their rights away. And let's really understand what Section 2 of the Voting Rights Act was and why it mattered. Because Section 2 was the most powerful tool that minority voters had to challenge discriminatory maps. Section 2 said that if a voting practice has a discriminatory effect, it is illegal regardless of whether the state intended to discriminate. This was called the effects test. And the effects test was hugely important because it did not require proving intent. It did not require proving that someone said something racist. It just required showing that a map had a discriminatory effect on minority voters. And this effects test was added to the Voting Rights Act specifically because proving intent is almost impossible. States do not write down racist intent. States do not say we are discriminating against black voters. States make up pretexts. States say we are drawing compact districts or we are keeping communities together. States come up with race-neutral justifications for what are actually discriminatory maps. So Congress said we are not going to require proving intent. We are going to make it illegal to have discriminatory effects regardless of intent. And that standard worked. That standard allowed courts to order states to draw districts where minority voters had a real chance to elect their preferred candidates. That standard was used thousands of times to challenge discriminatory maps. That standard was one of the most important voting rights protections in American history. But now the Supreme Court has reversed that. Now you have to prove intent. Now you have to prove that the state intended to discriminate. Now you have to show racist intent or statements. That is an impossibly high bar. That is essentially making Section 2 unenforceable. That is gutting the last major protection in the Voting Rights Act. In the specific case that triggered this ruling, in Louisiana, a lower court ordered the state to draw a second majority black congressional district because the state's original map had packed black voters into one district, diluting their power. The second district would have given black voters a real chance to elect their preferred candidate. But the Supreme Court conservative majority said that considering race in this way violates the 14th Amendment. The court said that you cannot consider race even when the purpose is to undo the effects of racial discrimination. This is the ultimate in colorblind ideology. The court is saying that even though Louisiana's original map had a discriminatory effect, the remedy cannot consider race. The court is saying that you cannot fix discrimination by considering the race that was discriminated against. The court is saying that the only way to comply with the 14th Amendment is to draw maps that ignore race, even if that means allowing discriminatory effects to persist indefinitely. And this is particularly brazen because the Voting Rights Act was passed with Republican support. The Voting Rights Act was a bipartisan achievement, but the conservative court is dismantling it. The conservative court is saying that the Voting Rights Act is unconstitutional. The conservative court is overruling Congress. The conservative court is deciding that voting rights protections that Congress put in place are not permissible under the Constitution. And here is what is important about the Shelby County decision. In the early 2010 seconds, the Supreme Court gutted Section 5 of the Voting Rights Act. Section 5 required Southern states to get federal approval before changing their voting laws. That was called preclearance. And preclearance was hugely effective. Preclearance blocked hundreds of discriminatory voting laws before they could go into effect. And the court said preclearance was no longer necessary. The court said that racial discrimination in voting was no longer a problem in America. But immediately after Shelby County, Southern states started enacting a wave of discriminatory voting laws. States passed strict voter ID laws. States closed polling places in minority neighborhoods. States made it harder to register to vote. States purged voter rolls. And the court allowed all of it because preclearance was gone. The court said, we do not need federal oversight anymore, and Southern states responded with a wave of voting restrictions. And now the court is gutting Section 2. The court is removing the last remaining protection in the Voting Rights Act. The court is systematically dismantling the entire law. And after this ruling, the Voting Rights Act is essentially meaningless. The law is on the books, but it cannot be enforced. The law provides no real protection. The law is purely symbolic. And the implications for the upcoming election and beyond are enormous. Republican legislators are going to redraw maps over the next 2 years. Republican legislators are going to eliminate black majority districts. Republican legislators are going to flip Democratic seats to Republican. We are talking about 10 to 15 or more seats flipping red. We are talking about potentially changing which party controls the House. We are talking about fundamental changes to the political map. And in a House where Democrats and Republicans are separated by just a handful of seats, flipping 10 to 15 seats locks in Republican control for a decade. If Republicans gain 10 to 15 seats, they could have a 20 to 30 seat majority. A 20 to 30 seat majority is filibuster proof in the House. A 20 to 30 seat majority is veto proof. A 20 to 30 seat majority means that Republicans can pass whatever legislation they want, regardless of how Americans vote. And this is durable because the court's conservative majority will last. Even if there is a Democratic president who could appoint new justices, the conservative majority will still be there for years. Even if Americans vote for change, the court will block that change. The court is locked in place. The court's decisions will shape politics for decades. And this is a fundamental attack on democracy. Democracy means that everyone has a fair chance to vote and that voting power is not diluted. Democracy means that the party that gets the most votes wins. Democracy means that elected officials represent the voters. But the Supreme Court is dismantling all of that. The court is allowing voting power to be diluted. The court is allowing maps to be drawn in ways that guarantee Republican wins. The court is overturning the will of the voters. And Americans need to understand that this is not an accident. This is not a coincidence. The conservative court majority deliberately voted to weaken voting rights. The conservative court majority deliberately voted in a way that benefits Republicans. The conservative court majority is making political choices and dressing them up as legal rulings. And the implications for democracy are catastrophic. And let's be very clear about what happens next. Republican legislators are not going to wait. Republican legislators are going to start redrawing maps immediately. Republican legislators are going to eliminate black majority districts. Republican legislators are going to split minority voters across multiple districts. Republican legislators are going to pack minority voters into fewer districts. And there is nothing that anyone can do to stop it because the Supreme Court has just said that it is legal to do this. And this is democracy dying. This is the institutions that are supposed to protect voting rights actively destroying voting rights. This is the Supreme Court, which is supposed to protect the Constitution, actually violating the Constitution. This is power being seized by judicial decree, and Americans need to wake up to what is happening.